We now have a quorum, Honorable Minister.
We do?
The other one come through there.
Mr. Chair, we that's because you do it so often. Yeah, Mr. Chair, I move that the bill be amended by inserting after clause 3 the following clause. The marginal note to read insertion of new section 21A, division of land for estate purposes. 3A. 1. The principal law is amended by inserting after section 21 the following section. Division of land for estate purposes. 21A1. Upon an application by the A. personal representative of an estate, B. beneficiary of an estate, or C. proprietors where the parcel was previously transferred by a personal representative to persons entitled under a will or on intestacy. For the division of a parcel into two or more parcels, the registrar shall effect the division by closing the register relating to the parcel and opening new registers in respect of the new parcels resulting from the divisions and recording in the new registers all subsisting entries appearing in the closed register. 2. An application under subsection 1 shall be accompanied by a plan prepared by a surveyor authorized under the Land Surveyors Law, 1996 revision. 3. For the avoidance of doubt, where a division of a parcel has been effected under this section, any application for development purposes in relation to any of the new parcels shall be subject to the requirements of any planning law for the time being in force. Subsection 4. Cabinet may make regulations prescribing anything necessary or convenient for giving effect to the purposes of this section.
The amendment has been duly made. Does the minister wish to speak thereto?
Just very briefly, Mr. Chairman, and the member from Northside can add whatever he so deems. But just to summarize the purpose of this amendment, for many years, Mr. Chair, there have been situations with families where estates are left unattended and where there are situations where there are parcels that do not actually have proper road access. And many families simply wish to subdivide parcels to give siblings and or other people the portion of ownership of those parcels that they should have. There has always been the difficulty of not being able to subdivide such parcels without having proper road access. What this does to allow for this is that this will allow, as it says in the amendment, for a surveyor, a qualified surveyor, to do the partition of the necessary parcel once all of the other requirements are met. And the registrar of lands can then give ownership to the individual parcels. What it does not do, and specifically, it does not allow for any development of those parcels until proper access is achieved, meaning any development which is to take place on such parcels would have to meet all of the other planning requirements and any other laws that are there. But what it does is it allows people to take ownership of the parcels, which I think has been a thorn for many families over the years. I do believe that it is also safe comment to say that the way it is nowadays, it would very likely be the eastern districts and the sister islands who will have situations more that this would assist. But certainly, the government was very sympathetic to the situation, and I want to thank the Honorable Attorney General, the Registrar of Lands, and all of the other persons involved from legal drafting, etc., to be able to, and planning, to come up with this, which will allow for these parcels to be created.
Honorable member from North Side.
Thank you, Mr. Chairman. And I just want to ask one question. In subclause 3, do we need to put in the word building between application for and development so that it wouldn't catch farming? Because I don't know, farming may be considered development of the land.
No, farming is not considered development.
Oh, okay.
Question is that the amendment, apologize, honorable member from East End.
Thank you, Mr. Chairman. Mr. Chairman, following on with Mr. Miller's thoughts there, farming does require an application to planning as well, do you know, to do that,
To do what?
to do farming,
Oh,
to get electricity and that kind of stuff?
that's a different matter.
Well, yeah.
Forgive me, but I mean, not to do farming. Let's not say it like that.
No,
Yeah.
to, to do,
But
develop anything on it when
but
it comes to the infrastructure.
for temporary meters for farming, there is a specific category in planning for that, and that would not require 30-foot road access to allow permission.
Well, if you get electricity in there, you got
Sorry?
need to get electricity in there. I guess you would need 30-foot road anyway.
Well, if that's the case, that's the case. But you are right with that. But what I'm saying is that that would not impede the ability to farm the property.
Yeah, you would need a 30-foot right away.
Right.
Anyhow
That would be
to-
it. Yeah, that's a different matter.
for the electricity company
Exactly.
to get access to it.
Yeah.
So the only way this is going to be registered is if you split it up, because people can do it in common, right? They can register their
Yeah.
lot in common and still
Right now.
and still it's split up. I don't know why we don't use that anyway. Proprietorship in
I
common
know what you say. I know.
does
what you
not
say.
give it the shares. If 4 people own the property, joint proprietorship, if 4 people own the property, every time one dies, it shares up amongst the others. Proprietorship in common means only it's 25% for each person, which is the same thing as subdividing. No, so why you don't go take that 25% when that one died? Does not go into his estate? Yeah, they don't have a title. Totally agree. Right. They won't have a title. It's one title. Here, when you subdivide it, you will get 4 different titles. Yeah, I understand that. But certainly, joint proprietorship would basically do the
It's
same
not
thing.
the same
with
thing, sir.
one title, but no one can do anything without the
That's the difference.
joint proprietorship. A proprietorship in common, you can do anything with your piece. Wait a minute. No? proprietorship in common too?
Yeah.
Honorable Premier, would you just speak to the microphone? I think it's helpful what you say. That's okay.
All right, don't worry about it then, but since you say I was wrong. I don't want you to say it.
Does
No,
another
that's
member
okay.
wish to speak?
I understand what the Premier is saying.
The question is that the amendment stand part of the clause. All those in favor, please say aye. Those against, no. The ayes have it. The amendment stands part of the clause. The question is that clause 3, as amended, stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 4, amendment of Part 2, insertion of new Division 3A, volumetric plans and volumetric parcels. Clause 5, amendment of Part 5, Division 5, Haydens.
Aye.
Question is that clauses 4 and 5 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. Clauses 4 and 5 do stand part of the bill.
Clause 6, repeal and substitution of Section 93, restrictive agreements.
Amendment, Honorable Minister.
Thank you, Mr. Chair. In accordance with the provisions of the relevant standing order, I move that the bill be amended as follows in Clause 6 by deleting the proposed Section 93 and substituting the following. Marginal notes, positive and restrictive covenants. 93(1). A covenant may be A, a positive covenant, or B, a restrictive covenant, and if registered under this law is enforceable against the covenantor and the covenantor's successor in title by the owner or occupier of land benefiting from the covenant. 2, where an instrument other than a lease or charge contains a restrictive covenant by one proprietor, restricting the building on or the user or other enjoyment of his land for the benefit of the proprietor of other land, and such instrument is presented to the registrar. The registrar shall note the restrictive covenant in the encumbrances section of the register of the land or lease burdened by the restrictive covenant, either by entering particulars of the restrictive covenant or by referring to the instrument containing the restrictive covenant, and the registrar shall file this instrument. 3, where an instrument other than a lease or charge contains a positive covenant by one proprietor mandating the building on or the user or other enjoyment of his land or other obligation for the benefit of the proprietor of other land, and the instrument is presented to the registrar. The registrar shall note the positive covenant in the encumbrances section of the register of the land or lease burdened by the positive covenant, and in the property section of the land which benefits from the positive covenant, either by entering particulars of the positive covenant or by referring to the instrument containing the positive covenant, and the registrar shall file the instrument. 4, unless it is noted in the register, a positive or restrictive covenant is not binding on any person acquiring the land or lease. 5, insofar as a positive or restricted covenant is capable of taking effect, not only the proprietors themselves, but also their respective successors entitled shall be entitled to the benefit and subject to the burden of the covenant respectively, unless the instrument otherwise provides. 6. A positive covenant shall not prevent a person from A. registering an interest under this law, B. exercising the person's rights under a registered interest, or C. releasing or surrendering a registered interest. 7. A proprietor of 2 or more parcels may enter into a positive or restrictive covenant with himself. 8. Registration of a positive covenant has effect only in relation to a positive covenant registered after the coming into force of the Registered Lands Amendment Law 2017.
The amendment has been duly moved. Does any member wish to speak thereto? Honourable member from East End.
Mr.
Oh, sorry.
Mr. Chairman, I would like to, but I got so much papers on this desk, I don't know if we'll ever find the bottom of them again. And I'm having difficulty finding.
There you go.
Oh, no, this is about the division. That's about the division. Mr. Chairman, I do apologize, but this forest that we have cut down here is now, instead of it being vertical, is now becoming horizontal. Horizontal forest.
Ms. Myrtle? As you people would say, out of an abundance of caution, please look at this and tell me this is what I should be reading from for the water sector. Please. Please just make sure, if you don't mind. What? Registered land law. No, I just started that, but that's not too much. All left after this is the water sector regulations, one that I have to recommit. That's all left after this before we get to Whiskey Papa bill. I have to recommit it. So this is the last one before that.
Honourable member, did you get a copy?
Aye.
Mr. Chairman, while he's
Honourable
looking
member
for
from
his,
North Side.
yeah, can I ask a question? What is the point of subclause 4 if the act of registering the covenants not going to give them any more authority than not registering them?
Honourable Minister.
I would have thought that the whole purpose of registering them is that they would have greater validity and be enforceable.
You mean unless it is noted in the register?
It says the note of the positive or restrictive covenant register does not give the positive or negative covenant any greater force or validity than it would have had it not been registerable under this law and had not been noted. No. I don't read it that way. The principal law, this is covenants under the registered land law.
Mr. Chair,
Mr. Minister?
as I understand it, this is what it obtains in the current registered land law. And all we're doing here is adding the positive covenants to it because it only speaks to restrictive covenants in the law as it is now.
Honourable
the
member for
question-
Northside?
The question I have is, and I believe up to this point that planning and the courts have refused to enforce some of these covenants that people may put over subdivision land, for instance. I would think that the reason we're putting it here now is so we could register them and therefore they would have more authority and be enforceable.
But the final arbiter is the courts. So even if they are registered and somebody is aggrieved,
Right.
they can still go to the court.
But wouldn't the
not-
court,
and the court can decide.
so why we need it here at all then? If the court, because wouldn't it be easier for the court if they were enforceable? Only if they were registered?
Mr.
In the
Chairman.
law, in the law. Yeah. But in the law, as it is now before this, it says the note of a restrictive agreement in the register does not give the restrictive agreement any greater force or validity that it would have had it not been registrable under this law and had not been used. Insofar as the restrictive covenant is capable of taking effect, not only the proprietors themselves, but also their respective successors entitled, shall be entitled to the benefit and subject to the burden of it, respectively, unless the instrument otherwise provides. So it's 4 that you're asking about, which reads, the note of a positive or restrictive covenant in the register does not give the positive or restrictive covenant any greater force or validity than it would have had it not been registrable under this law and had not been noted. So really all this is adding is positive covenants to what exists in the law now.
And the problem we have had with these covenants is that, at least in some cases, the courts have opted to ignore them because they weren't registered.
Honourable
And what I'm
Minister?
saying is that if we're going to
Register
allow for
them.
the registration
Yeah.
for positive
And-
and restrictive covenants,
Yes, which is what this is doing.
then what I'm saying is that I would think that we would want to say that if it is a registered restrictive or positive covenant, it is enforceable. And if it is not registered, it is not enforceable.
No, you see,
Honourable
yeah,
Minister?
but the fact that it is registered, listen, just listen now. What do they call it? Common law practice and everything else. Something is registered. It does. This is not saying that it's not enforceable. But all this does, in the same line as the law that exists now,
That-
is leaves the court to be the final arbiter. And the point, I mean, when you say it is enforceable, what you're saying is once it's registered, it's finished. And you can't leave it like that because it might be registered, but somebody might have a case to show that while it was registered, there is some injustice done in the whole process or whatever that nobody else knew about. It's all about leaving where the buck stops.
You're just forcing my people to have to go to court when I could simply register something and it was enforceable on my piece of land.
I can't agree with you, sir.
And they got cost them $60,000 and the land only worth
I
$5,000.
could agree with you if it ended there. But the same people that you say it's costing could be aggrieved or some injustice could take place for them. And if we do it that way, they have no recourse.
Okay, second question. Does this apply to existing covenants? The register don't make no difference, Arden? He just told me it doesn't. Read it.
It's not retroactive, sir. The legislation is not retroactive.
Honorable member from East End.
Thank you, Mr. And you know where I'm coming from now. This thing, government should not be registering personal agreements between people unless there's a fee to be paid on it, such as a lease. We put these covenants in there.
We got what?
We put these enforceable covenants in there. We're going to create classes of developments in this country, where ordinary persons cannot go in there. They gotta have a certain class. We have been known for mixed. So you're telling me
I'm not telling you anything. I'm trying to
that a
understand what you're saying.
subdivision,
Yeah.
when they put those covenants on, they can go and register them.
But you
Where
can
in
do that
Cayman
now.
have they done that?
Honorable
That they're
Minister.
enforceable?
Honorable Minister.
Say what? No. Restrictive covenants, as I understand it, let me finish. Restrictive covenants, as I understand it, are registered now and enforceable now through the courts. Yes.
Honorable member from East End.
So how come planning doesn't enforce them? When, whether they're registered or not, when you go, and I'm gonna give you a classic example. In my subdivision, there were covenants in the sales agreement. But this can make it no count. Hang on. They were supposedly notation on the registry. They were notation on the registry.
I know that.
They were submitted with the registration of Savannah Acres. I'm telling you,
Submitted where?
to registrar.
Where you bringing planning into it? Planning don't enforce
now.
covenants.
Okay. When planning enforces everything else, if you're going to develop,
No. Planning, but no. You can't bring up planning. Well, I don't mean you can't. Obviously you can. But planning, it is not the job of the planning department to enforce covenants. That's a legal matter.
well, let me explain to you.
That is why the final arbiter is the courts.
Let me explain to you.
I will allow
Honorable member
that
from East End.
quite
When
readily.
a person came into that subdivision, the half acre required a minimum of 2,700 square foot house. Someone came in there and was building like a 1,900, 2,200 square foot house or something. There were objections from the developers to planning.
But they needed to go to court.
Precisely because it was a private arrangement, it should never be registered to be enforceable.
No, for the court to deal with it, it has to be registered. That's the whole purpose of this. But if anybody is aggrieved, they go to the courts because they are the final arbiter.
So you're
The
saying then,
purpose of the registrar of lands is simply to
so
facilitate the
mean you have a
registration.
contract between us and need be registered?
If you want it to be enforceable, there has to be some instrument.
Absolutely.
And that's why it has to be registered to be enforceable. And then if there is any argument about it, then the final arbiter is the courts.
So planning wouldn't have,
No, planning don't have any authority over that.
so you're saying, once you register these covenants now, and the provisions are made here, when someone goes, say, a simple example, you go to buy a property in a subdivision,
Yeah. Somebody asks, what are the covenants?
the covenants are registered,
Okay.
and it says you can't build under 4,000 square foot
Right.
house. And the person goes to planning to apply to build a house, and he's 3,500 square feet. What happens?
Planning does not have the information on every subdivision which speaks to the covenants and all like that kind of stuff.
Okay, understood. But planning, that the architect does a block and parcel that is there. Planning, in their consideration of that plan, goes to registrar to see if what was submitted is correct. Surveys, that kind of stuff, right? Isn't that part of the planning process?
I wouldn't know all the details, to be very honest with you,
Well, how they gonna say that it got the right setbacks?
because they have to provide a survey.
Provide, precisely. They're not gonna provide it to planning.
Hold on one second.
Honorable Minister,
What Arden is asking is if somebody brings in a plan and it shows setbacks, how does planning verify that? By going to the registrar? They what? I know that. The way it works now, which is how I thought it did, is the developer and or persons aggrieved who are part of that subdivision would have to go to court. It is not the responsibility of the planning department. Planning does not go to the registrar to decide on this, whether the setbacks are correct or anything. When somebody submits a plan, they have layers and layers, and the plan will speak to the size of the parcel, signed off by somebody who is authorized to do so. And then the process continues on with electrical, plumbing, and they get their red card and all kinds of stuff. But when it comes to registered covenants, it is not the job of planning to enforce those covenants one way or the other.
All I'm asking is, and you're answering it, but you've gone around 9,000 times in a
Because
row.
it comes down to what I'm saying to you.
Does planning refer to registrar
No,
for any information? So you should have said
I would
no,
never say, I shouldn't say for any information, depending on the specific.
related to that.
Yeah,
to
but
that,
it
to that
no, not
application.
really, no,
That's all I'm
because it's
asking.
not their job.
Okay.
Good.
So if someone submits a plan and it doesn't meet the requirements of that covenant that is registered,
Then
hang
it-
on, it has to be brought forward by the aggrieved person, who would be the developer or the next door neighbor
Right,
or
oh, yes,
something of that
exactly.
nature.
Exactly.
And they would have to take it to court
That's right.
and prove that it was registered and you were aware of the registrar
That's right.
when you bought the property.
Yes, sir. Well, whether you were aware of it when you bought the property or not, somebody is responsible for it, and you should know whether or not there are any covenants if you buy property.
Right.
Yeah.
So
That's what obtains.
as long as planning don't
No.
verify all these things
Not no-
upon
not that
upon
part of it.
application for that.
No. I get bogged down enough as it is. Imagine what would happen if I had to do all that. And I'm not being funny when I say that.
And I understand, even if it doesn't, if the next door neighbor object to that planning application, is for them to prove
That's right.
that something is wrong and take it to the courts. Okay.
The question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no.
Thank you.
The ayes have it. The amendment stands part of the clause. The question is that clause 6, as amended, stand part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 7, amendment of section 95, release and extinguishment of easements, profits, and restrictive agreements.
The question is that clause 7 do stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 6 stands part of the bill. 7 stands part of the bill.
Clause 8, amendment of section 96, discharge and modification of easements, profits, and restrictive agreements.
Honorable Minister.
Thank you, Mr. Chairman. In clause 8, I would ask to be inserted after paragraph D, the following paragraph, DA. In paragraph B, by inserting after the words such user, the words to a different extent from that which could reasonably have been foreseen by the original parties to the easement, profit, positive or restrictive covenant at the time of its creation, and.
Does the Honorable Minister wish to speak there too?
No, sir.
The question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question is that clause 8, as amended, stand part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 9, amendment of Part 5, insertion of Division 5A, dedication of land for public use.
The question is that clause 9 do stand part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. Clause 9 stands part of the bill.
A bill for a law to amend the Registered Land Law 2004 revision to make provision for the registration of volumetric plans and parcels, registration of positive covenants, and the dedication of land for public use and
I
for
got a last
incidental
one
and
to do.
connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Thank you all very much.
Those against, no. The ayes have it. The title stands part of the bill.
Mr. Chair, if I might just say a special thank you to the technical team who have been here for quite a long time and several days to get this far with it. I certainly do appreciate their help.
Thank you. His preliminary indication was that Honorable Minister, You indicated that you were going to try and postpone the
Sir,
recommitment.
Sir, I just saying to you, if we can be quorate, I will, looking at the time, I will try my best to press on as far because time is against us. And I do recognize that. So I was just, we just need to be able to be quorate. And I will continue on. To them, but listen to me. Tell later, all right, tell later I'll call her. I'll call her a little later. I know. Mr. Mr. Chair, we have gone through 95% of this already, and it has been approved. And I am just wondering whether we could simply get approval, if I may use the term, if it's appropriate, en masse, for the recommittal of the bill and for the new amendments as filed, if that is possible.
Amendments is what?
As filed. These are the new ones that have been filed. So, I don't know. Maybe the Honorable Attorney General might be able to
Honorable AG.
advise us. But if they're going to agree, we need to get a quorum very swiftly.
Honorable Attorney General.
Mr. Chairman, first of all, as indicated,
Card is good.